Good to see you again, Mr. Inspector General. We appreciate you and all the great members of your team, and I want you to know we do read your report. Just yesterday, I was questioning the ATF director about why they weren't following some of the recommendations you put forward, and I know that work is appreciated. I also take note of our distinguished ranking members' call for this FISA reform to be bipartisan and to be nonpartisan, which at times are two different things. And I think it is thoughtful and mature, and I will do all I can to resist the temptation to frequently point out that the very political weaponization that Ms. Williams testified about is often directed against Republicans. But based on the ranking members' solemn and I think thoughtful advice, we'll try to avoid seizing on that point as frequently as we might otherwise. I want to get into the 3.4 million backdoor searches that the ranking member pointed out in his opening statement. Mr. Inspector General, how should the public think about those?
Well, I think what we've seen in the various public reports, and I'm limited in what I can say about what's public, which I think is one of the issues, by the way, that we're talking about is transparency here. It's obviously very concerning that there's that volume of searches, and particularly concerning the error rate that was reported on in the last 2 years in the public reporting.
Now, and that error rate was what?
I believe it was around 30%. I think so remembers. I think it's around 30%.
Well, 30%. I'm a lawyer, not a mathematician, but 3.4 million, about 30%. You're talking about 7 figures of error in terms of these searches. I'm wondering how many people can perform these backdoor queries?
I'm going to defer to board members because you have the review ongoing.
I'm afraid I don't have those figures at my fingertips in terms of the number of people that can conduct those types of searches. But I share the concern expressed in the question that we need to have greater safeguards, and I urge Congress to incorporate a requirement for FISA court review of these kinds of searches to protect Americans' Fourth Amendment rights.
3.4 million backdoor searches, more than 1 million of them in error. If I represent to you that we believe there may be north of 10,000 people in the federal government that can perform those queries, would anyone here have a basis to disagree with that assessment?
No.
So FISA is unique in our jurisprudence because it's not an adversarial process. Most of us think about justice where there's a lawyer on one side, a lawyer on the other, and then a judge or a jury makes the decision. But here in FISA, you've got just one team and the referee, and you don't have a defense attorney or an advocate there to point out these things. Given that FISA isn't adversarial, how does that increase the importance of the Department of Justice taking the recommendations of the Inspector General as you laid out over the years?
Congressman, I think it's critical, and you're exactly right. It's one of the concerns we saw in the Title I work we did on the Carter Page files, which is, to some extent, the FISC is relying entirely on what the government tells it. So in some respects, it's unfair to look to the FISC to try and do the kind of work that, as you noted, a defense lawyer would do. I was a federal prosecutor. I was a defense lawyer as well. There's a search for the
I'm a little annoyed they don't hold the federal prosecutors in contempt to come before them and don't present complete evidence.
Can I just I'll just say on the Carter Page files, one of the problems that we found, one of the serious problems we found, was the FBI was sitting on information and wasn't telling the prosecutors.
See, if I was in a civil litigation environment in North Florida and I was withholding evidence that the other side had a right to, I would expect a judge to sanction me. I know you don't oversee the court, but perhaps a message that they would absorb. And speaking of messages to absorb, we have this non-adversarial process. We have these 3.4 million backdoor queries, more than 1 million of them in error. And it just doesn't seem like DOJ is listening and they're as quick on the uptake as they should be. In 2019, you write a 478-page report detailing the problems. In 2020, you publish a management advisory that lays out the problems. In 2021, you lay out additional reforms, and it seems as though every time you write a report and then the DOJ comes in and tells us that they now have fixed everything and have cleaned the light, and then you write another report showing that there hasn't been sufficient compliance. I know there's a report coming after this hearing, but I think that just continues the cycle until we constrain these authorities.
Gentleman's time has expired. Chair recognizes the gentlelady from Texas, the ranking member, Ms. Jackson.
Thank you very much. Good morning. Ms. Franklin, when Congress reauthorized Pfizer in January of 2018, we added a provision requiring the Attorney General to develop procedures for querying information in the 702 database to be reviewed by Pfizer Court as part of its annual certification. Can you explain why having clearly defined querying procedures can help protect Americans' Fourth Amendment rights?
Thank you for that question. Yes, I agree that requiring specified querying procedures is important. Previously, the rules that applied to querying were contained in minimization procedures. They've now been fleshed out and documented further, and we just had a release recently this week by the FBI of a public version of the querying procedures. And having clarity can help prevent the kinds of compliance violations that we have seen. However, I would urge that those are not sufficient. I believe that in addition to having specified rules, which are approved by the Pfizer Court, Congress should incorporate a requirement that individual queries be submitted to the Pfizer Court for review to ensure full protection.
So in any reform, you would add the individual queries as well for clarification and transparency
Yes,
within the intelligence community.
Well, I think Pfizer Court review can help. The individualized judicial review is important because in this program we do not have individualized judicial review at the front end. So when we are looking, when analysts are looking for the information about specific Americans who have recognized Fourth Amendment rights, to have the judicial review at that point.
And Professor General Horace, in the 2018 reauthorization of Section 702, Congress made some small changes to the law to protect U.S. persons whose communications may be swept up in 702 collections. One of the changes was to impose a limited warrant requirement for U.S. persons who are the subject of an open criminal investigation. How has the warrant requirement been used in practice? What impact?
Let me get back to you on that. I want to make sure that I'm fully informed on that. I have not looked at that recently, and I want to be careful on how much I can say in a public forum at this point. But frankly, one of the challenges in talking about the use of these tools is how much remains classified and how only in the last recent months have we seen information coming forward. So I need to get back to you if I can on that, Congresswoman.
I'm going to take a leap, but you notice that I mentioned the young airmen. As I recall, what is in the public domain is that there may have been some foreign contact that may come to our attention. We were all appalled at that. I'll just take a brief moment on that before I ask Ms. Franklin a very quick question. We were all appalled at that, so I want to just frame what we need to do to secure 702, but just give us, if that was the case, and if there was a need to engage, how the 702 would be utilized.
Well, I think the important point, I'm not going to talk about any specific things. The general matter you mentioned is the need to get a warrant in certain circumstances. That requires a court. You don't self-issue a warrant. And that creates the oversight process that I think the chair is referencing more broadly as a means by which there would be further court review in other areas as well.
I have a question for her. She can follow up on that if she desires, but let me do the question. I think I just want to get to the point. It wouldn't be willy-nilly, if I may use that terminology. You need to, the FBI needs to well document.
It depends what they're trying to do, I think is the right answer, if I may. I don't know.
Well, she can, let me pose this question that you might want to expand. Is it clear whether the small changes in the 2018 legislation reauthorizing Section 702 have improved the administration of Section 702?
Thank you. I believe this there have been some benefits, as I just discussed, regarding the requirement for clearing procedures that has helped, but I do not believe that those changes were sufficient, and I urge Congress to incorporate more robust and meaningful safeguards, such as the three that I mentioned during my opening remarks, including requiring account of extended incidental collection, requiring private court review of U.S. person query terms, and preventing the restarting of about collection.
I thank the witnesses.
I thank the gentlelady.